Well, the part that I love is the masks are being used to rob banks. Oh, somebody noticed that finally. Well, where's my rope transparency act? It's being used to tie damsels to train tracks. It's like the old-timeiest justification you could find for a mask ban.
Freedom of speech.
Fundamental rights.
Freedom of conscience.
Academic freedom.
Freedom of press.
And the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights and Expression. Welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. I am, as always, your host, Nico Perino. Today we're going to do something that we haven't done in a couple of episodes. We're going to do a news roundup. We're going to look at the biggest free speech stories of the past few weeks, and we have a busy agenda. What are we talking about this week? We're going to talk about Tim Walz's controversial take on hate speech. We're going to look at California's deepfake laws, plural, and we're going to look at the 3 tenured professors recently fired or suspended for their expression. Plus, we'll cover Nassau County's new mask ban and the legal uproar that's ensued. To do this, joining me today in FIRE's DC podcast studio are FIRE's own Aaron Terr, our Director of Public Advocacy. Aaron, welcome back.
Good to be here.
To his right is Murnane, Campus Advocacy Chief of Staff here at FIRE. Connor.
Thanks for having me.
Is this the first time on the show?
This is the first time.
Well,
Long
welcome.
time listener, first time caller, all that fun stuff.
Very good, very good. It's good to have you. Adam Goldstein, you've been on the show before. You're FIRE's VP of Strategic Initiatives. I think last time we were talking about intellectual property and copyright and fair use and all that fun stuff, but it's been a couple of years.
It has been. Glad to be back.
All right. Aaron, Connor, Adam, welcome onto the show. Let's start with Tim Walz's comments on hate speech and free speech. Last week, during the VP debate, Minnesota Governor Tim Walz incorrectly claimed there is no First Amendment right to hate speech and cited the widely misunderstood shouting fire analogy, which is often misapplied to free speech debates. Let's play that clip.
The most sacred right under the United States democracy is the First Amendment. You yourself have said there's no First Amendment right to misinformation. Kamala Harris wants to use the power of government and big tech to silence people from speaking their minds. That is a threat to democracy that will long outlive this present political moment. I would like Democrats and Republicans to both reject censorship. Let's persuade one another. Let's argue about ideas, and then let's come together afterwards.
You can't yell fire in a crowded theater. That's the test. That's the Supreme Court test.
All right, Aaron Terr, is that the Supreme Court test?
That is
fire in a crowded theater?
That is not the Supreme Court test. Although if you stop reading Supreme Court First Amendment case law in 1919, then you might think that it is. But yeah, that's a phrase that goes back to a case called Schenck v. United States. It was penned by Justice Oliver Wendell Holmes, and the case was actually about World War I protesters. They were encouraging people to peacefully resist the draft, and Justice Holmes used a metaphor to explain that there are limits to free speech. What he actually said was you can't falsely shout fire in a crowded theater and cause a panic. And he would later reform his views pretty quickly, actually, I think within months, and actually became one of the great justices who defended the First Amendment and started to make it into the speech protective law that it is today. But that phrase, fire in a crowded theater, of course, endures on, and you often hear it recited by people who are trying to justify censorship of things that really have nothing to do with fires or theaters.
Well, that's the question, right? So can you shout or falsely shout fire in a crowded theater and have it be protected by the First Amendment? One of the things I learned is that there's a suggestion that Oliver Wendell Holmes, when he was writing that majority opinion in Schenck, was making an oblique reference to an incident that happened, I believe, in 1913 in Calumet, Michigan, at an Italian hall where a group of union, I believe they were miners, but union workers and their families were having a Christmas party. And someone falsely shouted fire in the crowded theater. They think it was a union buster. And something like 73 people were trampled and killed. So can you, Adam, falsely shout fire in a crowded theater and have it be protected?
Well, it gets into this idea of the constructive speech or constructive action, where if your purpose in shouting fire is to create a panic that will then cause people to be harmed, you can't do that. But there might be other occasions where falsely shouting fire would be totally protected.
Fire,
Right? Like if this is an extreme example, obviously, but if you're in a play and that's the line and you're on stage, you should probably shout fire or else the play is going to drag. So there's nothing inherent about shouting fire falsely in a theater that automatically makes it unlawful, because falsehood also isn't automatically outside the First Amendment.
So you can, if there is a fire in a theater, you would probably be, you'd probably want to shout.
You probably should.
Yeah.
It would be antisocial behavior to not shout fire at that point.
Yeah, but if you're in a crowded podcast studio, so to speak, and I falsely shout fire like I just did, and nobody is under the false pretense that there is actually a fire, then that's probably not unprotected. So context matters. Was that how we get to the 1969 decision in Brandenburg, which is the current standard for incitement to imminent lawless action, right? It needs to be likely to do so, right?
The speech needs to be intended to cause imminent lawless action and actually likely to produce it.
So my shouting fire just a moment ago was neither likely to cause a panic nor intended to do so. So it wouldn't meet that standard. All right. But the phrase falsely shouting fire in a crowded theater is often used almost kind of like a tick or a reflex by people in free speech debates to justify all sorts of censorship. In this case, I think Tim Walz was using it to justify censorship or mis or disinformation. What other contexts have we seen it come up in?
Well, it keeps coming up a lot because it just stands for this underlying principle that there are things that are not protected by the First Amendment, which is an observation that I think unless you're a free speech absolutist and a First Amendment absolutist, which there aren't very many of them around, everyone would agree there are some things that are beyond the scope of the First Amendment. At which point we could move on. So you could just as easily, if you're someone prone to evoking this analogy, you could simply bring up copyright infringement, my favorite topic. Hey, I got there in one. That's not protected by the First Amendment. There's other types of unprotected speech, the locations of troops during war, right? So there's no reason to use it because all it stands for is the idea that, the First Amendment isn't absolute and eternal.
So it's substantivist. It's stating something that should be obvious to all people, though the problem is that it's just applied in contexts where the speech is clearly protected, such as in the context of hate speech, right?
Right. Hate speech would be the other big context, I think, where you often hear it. And it's the idea is that you're expressing hateful attitudes that might lead at some point into future to people to act on violent ideologies and result in some kind of physical harm to people. But it's this much more attenuated connection that doesn't satisfy that narrow incitement standard articulated in Brandenburg.
Well, that's how we get to the other comment that Tim Walz made during the debate, where he sort of is interjecting there where J.D. Vance is talking and suggesting that hate speech isn't protected by the First Amendment. He's made comments like this before in interviews. There's a misconception surrounding hate speech. I think a lot of people think hate speech is unprotected. The Supreme Court hasn't articulated a hate speech exception to the First Amendment. Has it, Adam?
No, there absolutely is no such thing. Hate speech comes up in our education work a lot because there's an obligation in anti-discrimination law to ensure that students aren't deprived of the value of their education by creating a hostile educational environment. And at that point, that doesn't make the speech criminal, but it does impose an obligation on the educational institution to try to ameliorate the effects of speech that would make someone feel unwelcome. But that's not a crime.
Connor, I recall we had a case, what was it, just after COVID, 2020, 2021 at Emerson College, where you had a Turning Point USA group that was handing out stickers that said China kind of sus on them. And for this, the college president sent out a community-wide email accusing the students of anti-Asian hate and bias. It was pretty clear by looking at the facts that they were just talking about the Chinese government. It was in the context of the COVID pandemic. But for this, they were punished. I think their group was suspended, and they were accused of hate speech, right?
You see it time and time again, especially after October 7th, right? We just saw those decisions from the Department of Ed, the cumulative harassment theory now, can any number of these individual instances add up to a, hateful or a harassing environment for Jewish Palestinian students. So
let's unpack that, right? Because individual instances of speech adding up cumulatively, we're talking about multiple different speakers here, to a hostile environment. So you could have one person that says, from the river to the sea, Palestine will be free. And maybe that doesn't constitute a Title VI violation. But if you have 3 people saying it, 4 people saying that, you have 10 people that are hostile to Israel or Zionism, it adds up to this kind of cumulative hostile environment, which downstream from that suggests that the college or university needs to punish each individual instance of speech lest they cumulatively become hostile, right? That seems dangerous.
Oh, it's entirely dangerous, right? Fire's been railing against speech police on campus for how long? And this is saying, look, now you need to watch out for the smallest incident because you don't know when we're going to add them up and say that's 10, that's enough.
Mm-hmm. So Tim Walz is wrong about hate speech going back to, you can look at the Skokie case, right, where the Supreme Court sent the case back down to the lower courts and said, no, there are First Amendment rights at play here. For those who don't know the Skokie case, and I've unfortunately found that many people don't know what that is, 1977-78 case involving neo-Nazis who wanted to rally in a town of 6,000 Holocaust survivors outside Chicago, Illinois. But then you fast forward to Texas v. Johnson, where you have the court say that it's a bedrock principle of the First Amendment that the government may not prohibit that speech which society finds deeply disagreeable or offensive. And then you get to Snyder v. Phelps, where you have protesters outside the funerals of dead military soldiers with signs that say God hates fags. In the Supreme Court, I think that was an 8-1 decision with Alito in the dissent, saying, no, this is protected speech. And you have the court saying that our Constitution means anything, it means the right to say something that we find, again, offensive. And then you have Mattal v. Tam, right, where you have a Asian rock group that wants to trademark the name Slants, to sort of reappropriate it, pejorative against Asians. And the Supreme Court upholds their right to do so. So this is pretty well-worn Supreme Court doctrine.
Yeah, how many times do they have to say that there's no exception for hate speech before this canard will finally die? But yeah, it is a bedrock principle, as the court itself said, of First Amendment law, that you can't restrict speech simply based on a judgment that it's hateful or offensive. And one of the main reasons for that is that the judgment of whether speech is hateful or offensive is in the eye of the beholder. It's subjective, and it's strongly influenced by people's political and cultural biases. So it makes it very easy to wield that standard for both sides of the political spectrum, to wield that standard to shut down opposing views.
But because hate speech doesn't have a definition, there are some things that would be unprotected by the First Amendment that might constitute hate speech, right?
Sure.
Like
there
what?
Can be overlap. So some speech that meets the standard for incitement, for example, could also be considered hateful. If you have the KKK standing with torches in front of someone's house, and the grandmaster or the leader or whatever orders them to set it on fire, because it's the house, it's a black person's house or a Jewish person's house or whatever, I think people would reasonably consider that hateful. But the reason it can be punished isn't simply because of their hateful views, but because they're about to set this, it's speech that is likely to result in the imminent physical destruction and possible injury of people inside the house.
So that's kind of like the Virginia v. Black case, right, from the 1990s, where Virginia had a statute that said that burning a cross, even on private property, the Klan does this, would be de facto intimidation. And the court was mixed on it, and it essentially said, no, this is expression, and it can't be prima facie evidence of intimidation. But it might, contextually, if you take it all as a whole, be evidence of intimidation, which could constitute a First Amendment exception. Am I right about the retelling of that case?
Yeah, and that's a different First Amendment exception, which would be true threats or intimidation, where you speech that expresses a serious intent to inflict physical harm on an individual.
Okay.
But right, it has to, the circumstances and the context around the cross burning have to send that message of a physical threat. But absent that, it's just speech that some would consider hateful or offensive.
So closing out Walz here, is he kind of half right on both of these? Like, yeah, in certain contexts, falsely shouting fire in a crowded theater might be unprotected speech. And yeah, in certain contexts, hate speech might not be protected. But it's his kind of reflexive retort to these two claims and how we've seen them wielded in the past and in different contexts that's the problem.
I think it can be confusing with it to just a average member of the general public to hear, if you just hear a politician saying there's no First Amendment protection for hate speech. I think in their mind, they may easily think, right, that it's not just that there are these, specific, very narrow circumstances where hate speech might meet an established First Amendment exception and therefore the government can restrict it. But I think they're more likely to just think that, like if you just say things that seem racist or bigoted towards or hateful towards a certain group, then the government can ban that. And it's just not that expansive of a government power.
All right, let's move on now to California's package of deepfake laws. They passed 3 laws, and it seems like the impetus, at least for one of them, if not all 3, stemmed from a unique engagement that Elon Musk had with the governor of California, Gavin Newsom. There was this video created by Christopher Coles that's, you could call it a deepfake, a deceptive video of Kamala Harris. It's a campaign ad.
I wouldn't call it deceptive, but...
Yeah, because it's parody and satire, and I think anyone who's watching it, maybe we can cut some clips of it in here, lest we fall afoul of the deepfake law, though it's enjoined, and we'll get to that.
I, Kamala Harris, am your Democrat candidate for president because Joe Biden finally exposed his senility at the debate. Thanks, Joe. I was selected because I am the ultimate diversity hire. I'm both a woman and a person of color. So if you criticize anything I say, you're both sexist and racist.
It's very clear that it's not Kamala Harris. She's talking about how she's a DEI hire and Joe Biden is senile. Like, this isn't stuff that if you know anything about Kamala Harris would be in a Kamala Harris ad. But nevertheless, it was put out. It was retweeted by Elon Musk, and Gavin Newsom got upset by this video, presumably, and said that he was going to pass a law with the state legislature to make this sort of content unlawful. And so you get AB 2839, which is a law that regulates materially deceptive content that is distributed by people's committees or other entities with malice. It applies 128 days leading up to an election, and in some cases up to 60 days after. It creates a private cause of action, which my lawyers help me out here. That means that people can sue each other over this.
That's right.
And it does create an exception, though, for satire or parody, so long as you note, and it's clearly labeled, that this image, audio, or video has been manipulated for purposes of satire or parody. Nothing screams satire or parody like a label telling the audience that this is satire or parody. What's the problem with this? People have a huge concern surrounding mis and disinformation and the way that artificial intelligence can accelerate the mis and disinformation in society. What's wrong with the way that California approached it here, or is nothing wrong?
I mean, I agree with the judge who enjoined it. If we want to move on to that part, to talk
let's talk about
that,
October 2nd. On Wednesday, a senior U.S. District Judge, John Mendez, temporarily halted the law and said that while California has a valid interest in protecting the integrity of the electoral process, this law is unconstitutional because it lacks the narrow tailoring that a content-based law requires under strict scrutiny. Most of the law acts as a hammer instead of a scalpel, he went on to say, and it's a blunt tool that hinders humorous expression and unconstitutionally stifles the free and unfettered exchange of ideas.
Yeah, California went into this conceding that strict scrutiny applied. They said it was a content-based regulation. Strict scrutiny is the highest form of scrutiny the government has to use to review a law. It means that there must be a compelling government interest, and the law must be as narrowly tailored as possible in order to avoid infringing on other speech. And the problem here was requiring mandatory labels is not a narrow tailoring thing. Like there's a narrower tool we have here, which is other speech. And to tell people it's a deep fake, and also to assume people can identify parody. There's some like modification of Poe's law at work here, where it's sort of like the further opposed two viewpoints become, the harder it is for one extreme viewpoint to identify satire of the other, because it all sounds absurd to them, I think. Because like the idea that anybody saw this Kamala, deep fake and was genuinely confused seems improbable to me. But I guess if you really want to believe that the other side believes anything, then I guess maybe. But Nevertheless, you still have a remedy that is short of labeling, which is you tell them it's fake.
But you can't even share this to tell people it's fake, right? Isn't that one of the weird things about this law?
That's one of the problems with this law and a lot of similar laws that states around the country are passing to regulate AI and deepfakes is that they often they either don't have an intent requirement at all. So it's sort of like a strict liability where just sharing the content itself is a crime, right? Even if you have the intent to call it out as fake or to criticize it in some way. Or you just have a very watered down standard, like if you reasonably should have known that it was fake. So, and then we're just leaving it to the government, right, to decide when should someone have known that this video was fake, and that's enough to bring a criminal prosecution. So it's really, you can just see from that how massive a chilling effect these sort of laws can have.
California does have a knowledge requirement, right? It says with malice, knowingly distribute the advertisement.
There's a difference between just knowing that you're sharing something that you're sharing the content. I mean, I guess you always know that you're
if you're sharing the content to point out that it's false and deceptive, you're knowingly sharing the content, right? Are you doing it with malice? I don't know.
Well, in the context of, keep going back there, in the context of copyright infringement, when they say knowingly distribute copyright infringement, they don't mean knowing you infringe. They mean knowing you distributed.
Okay.
So if that's where they're getting this from, this might actually be, I could have no idea it's fake and redistribute it, and I have the mental state necessary to violate the law.
And by the way, there's also, so another problem with all these laws, including this one, is that there's also no requirement of actual harm to anyone. So I believe the language they use is something like reasonably likely to hurt a candidate's reputation or reasonably likely to influence the outcome of an election. But it doesn't actually have to do any of those things.
Isn't that what political speech is meant to do? You talk about candidates in order to influence the outcome of the election or learn more about candidates or harm their reputation?
Political cartoons for centuries.
Yes.
But even when you talk about exceptions to the First Amendment, like defamation, for example, there's a requirement that you prove that speech actually hurt your reputation.
You need to know what the actual damage was to determine damages. But this wasn't the only law that California passed. There was also one that places requirements on the platforms where this deceptive content might be posted. So this is AB 2655, and it's under this bill, platforms must block deceptive content about politicians, respond to every single public complaint about deceptive content within 36 hours, and filter and block any content that's substantially similar to that previously removed content. That seems like an incredible burden. I don't know how social media companies or any platforms that host third-party content would be able to comply with that with any sort of consistency.
Right, and they're what's going to happen is that they're going to err on the side of caution by suppressing speech that could even questionably violate this law to avoid constantly being dragged into court. And that's why this particular law is not only has a First Amendment problem, but a Section 230 problem, which is the federal law that broadly immunizes platforms from liability for what their users say.
That Hillary Clinton wants to get rid of. Right?
Yeah.
Didn't we just see that in the news?
Yeah.
And I posted about this on social media. It's not just Hillary Clinton that says we need to remove Section 230. It's also conservatives. Conservatives have wielded the repeal of Section 230 as a way to go after tech platforms that they think censor too much. But if you remove this third-party liability shield, they're just going to censor more because they're going to be more risk adverse, right? They're going to take down more content. So it's as I said on social media, it's not rocket science, right? Yeah. It's just incentives.
And by the way, requiring the platforms to respond to 36 hours to every complaint that they receive and make a snap decision. I mean, that's just so obviously going to be weaponized by people who are going to file complaints to target satire and political criticism that they don't like, even though, like the Kamala Harris video, it's obviously not deceptive or intended to deceive, but it's just satirical political commentary. And I mean, after all, right, that's what Governor Newsom, it was like the whole impetus for him announcing that he was signing this law soon was that he was going to make videos like the Kamala Harris deepfake parody illegal, right? So like you're just going to see much more of that if these laws aren't enjoined.
Yeah, and the judge...
And this one's being challenged too, by the way.
Oh, is it?
But the Babylon Bee, I think, is challenging this one as well.
Babylon
and they real quick, like they recently put out a video after these laws were signed as a deepfake of Governor Gavin Newsom, where like another obvious like parody where he starts out by saying something like, "Hello, this is a message from Governor Newsom in my 100% authentic, non-AI created voice."
Hi, I'm Gavin Newsom, the governor of California. This is a message for the people of America, given in my authentically recorded, non-AI voice. Thanks to my leadership over the last several years, California has become a world leader in extremist, left-wing governance. My policies were so effective that almost 1 million people are now fleeing the state every year. We even ran out of U-Hauls.
I like that it says you have to filter and block any content that's substantially similar to what's been previously removed. Isn't the whole point of a deepfake is that it's substantially similar? So if it's substantially similar to a deepfake, isn't it anything with that person in it?
That's a good point.
It just seems like the exception swallows the rule here. And also, like, why is it only like things that might negatively influence the election? Or if it just says influence the election, should we be policing, photo retouching? If somebody uses too much makeup, Kennedy should have been out of there. That was cheating.
Yeah, or like you make a deep fake of yourself, like saving like a drowning child or something like that, right?
Well, did you guys see that article in Pessimist Archive, which is this great Substack that I encourage all of our listeners to subscribe to, where he goes deep and looks at efforts in Congress to pass a law in 1912 outlawing photo editing? Because I guess there was something that was happening around that time where people were doing the analog equivalent of photoshopping themselves into pictures with William Howard Taft. And this was, people were very concerned about this. And Congress even got to the point where they were about to pass a law. They didn't, right? But this speaks to a larger panic that folks have. I won't go so far as to use moral panic, but anytime a new technology comes about, people get anxious. And it seems like one of the first reflexes is that government needs to pass a law to regulate this. Connor, I see you nodding your head over there.
I mean, we saw it with the printing press. We saw it with social media. Now it's AI, right? People are afraid of a computer being smarter than them, so they're going to come out. And when I look at these bills, I'm not a lawyer. I'll say that time and time again. I see the government saying, the people are morons and can't parse the content themselves. That's a problem. I don't want government making that decision for me or my future kids or whoever.
Yeah, what we're going to get to at some point after the anarchic period is just more media literacy. I think like we did with Photoshop, like we did with television. I don't think if Orson Welles did his War of the Worlds broadcast today that people would be in Times Square panicking. I am not opening up any emails from Nigerian princes promising me millions of dollars anymore. I think I've gotten the message on what email is credible and what is not. But AI is new, right?
Yeah. But I think like already at this point, media literacy is improving. I mean, I think, and also going back to your point about, right, the government can't just rush in to regulate speech that it thinks is false without showing that counter speech isn't an effective remedy. And I feel like every time that there's been a deep fake in the last few years of like a politician or a prominent public figure, there's been mass media coverage of it. It's been all over the conversation's been all over it on social media, like pointing out that it's not a real video, even in cases where it's like pretty clearly not intended to deceive anybody. So I think that's counter speech in action, showing that it does work. And FIRE senior fellow, I want to give a plug to Jacob Mashagama, who recently wrote an op-ed about how, despite all widespread fears about AI and deepfake, AI and disinformation upending elections this year, there's no evidence that they had any significant influence on any of the European Parliament elections or other elections around the world.
Yeah,
so
I think
far
he
this year.
cited elections in India as well. Yeah.
So yeah, I mean, I think it kind of is a panic, and that the government is rushing to regulate in this space based on the the worst imagined scenario of what could happen in the future. But I think right now there's really no reason to believe that this is going to be the end of democracy or just completely obliterate our ability to discern fiction, reality from fiction.
Well, yeah, one of the risks here is, of course, not only that you undermine the First Amendment, but undermine a new tool for communication and creative expression. I mean, we might get to the place where AI allows individuals on their own without any coding expertise to create video games in their own worlds for themselves, right? But if the government comes in and overly regulates it, that power for this new communication technology will be forestalled.
Yeah, there's a lot of positive applications of it too that we don't have to get into all of them, but just like give another example in creatively in TV shows and movies where they might use AI to bring back a character by like a deceased
like
actor.
They did in Star Wars.
Yeah, exactly.
Princess Leia, right?
There's even a really interesting use of AI to create a deepfake voice of people who have a condition that caused them to lose their voice. And there's actually a congresswoman who has used like AI of her own voice to be able to reproduce her voice and sort of be able to speak again.
Well, this allows me to pivot into something that I did want to talk about, which is you can regulate the use, but you shouldn't regulate the technology, right? So, for example, we have exceptions regardless of whether it's artificial intelligence or Photoshop or video or audio editing tools, whereby like you can't appropriate someone's name, image, or likeness for purposes they've not given permission for. Like there's the Scarlett Johansson case surrounding right to publicity where it is alleged that OpenAI pilfered Scarlett Johansson's voice to be the spokesperson for their new audio tool, right? There are torts that we have. There are exceptions that are well worn to the First Amendment, such as fraud and forgery, right to publicity, that we can use and apply to new technologies. We don't need to create new exceptions to the First Amendment to apply to these technologies.
Right. The AI itself is a neutral tool of expression. It can be used for good and it can be used for ill. The same way that like a pen, you can use a pen to write a beautiful poem and you could use a pen to defame somebody.
Yes.
The same sort of thing that came out when the VCR came out, right? And there was this argument, is the VCR burglars' tools for content? And ultimately, the court said, no, there's substantial non-infringing uses. You might just want to watch the game a little bit later in the afternoon. After your kid's soccer game, come home and watch and watch football or whatever. And so the question is, are there substantial non-infringing uses or non-criminal uses or non-offending uses for AI? Clearly there are. We've just listed a bunch of them. So the approach of we're going to regulate this technology to prevent people from using it is going to be wrong-headed 100% of the time. We have to focus on the people who are the bad actors.
Let's turn now to college campuses. There was a week here a couple of weeks ago where 3 tenured professors were punished. 2 of them were fired. 1 of them was suspended for their expression. Let's start with the one that I think is perhaps the most interesting because it's the most unique. This is Joe Gao at the University of Wisconsin-La Crosse. He and his wife had an OnlyFans account or something like that where they, on the side, would cook vegan food and then have sex on camera. I think their account was called Sexy Happy Couple. And last December, it was revealed that Joe Gao, who was the chancellor of the University of Wisconsin-La Crosse and also a tenured professor, did porn on the side. And UW-La Crosse was very quick to fire him in his role as chancellor. And then it began this long process to fire him as a tenured professor. There are more protections, I guess I should say, to firing a tenured professor, so it takes longer to do. Connor, was it okay from FIRE's perspective for him to be fired as chancellor? Let's start with that first decision the school made.
Well, more often than not, administrators don't have the academic freedom, right? The extramural speech protections that faculty member would. You also, as the chancellor, are representing the institution more than a faculty member. So we focused predominantly on what you covered there as teaching role. And for us, it boiled down to the fact that there was no impact on his teaching, and what he was doing in his spare time was, public concern, right? Vegan cooking, I guess that could be public concern. Sex positivity, adult relationships. And if I remember correctly, it wasn't just the porn account, right? I think he had the porn on one half, and then he had a safe for work YouTube where he'd do the cooking and the interviews. So, hitting multiple target audiences, it's just being a smart businessman.
But people have problems with, there's something about porn, right? That is sexuality different? The concern here, right, is that it'll make his job as a teacher hard because you have some segment of the students who have perhaps seen him naked, engaged in intercourse with his...
Are you telling me college students are watching pornography? What? Who else knows this?
I think something like 60% of Americans have watched porn or actively watch porn at any given time, right? But
So at least two people at this table.
but college students are college students. They're going to go seek this stuff out, right? It's interesting, presumably. So does that compromise his ability to perform as a college professor? And does the college university system have a vested interest in ensuring that his classes stay focused and that his performance isn't compromised?
Well, I think not to use the old term slippery slope, but I think it's apt here where you start going down that road of is what a professor says or the expressive activity that they engage in their personal lives outside the classroom going to affect kind of students' perceptions of them or in the other cases I think we're going to talk about like whether they can be treated fairly in the classroom. And you can start applying that to all sorts of political expression too, right? Where a professor expresses a certain political view on social media, and then people argue that they can't possibly be an effective or fair teacher given the view that they've expressed on this. They're going to have students who disagree with that.
You could have, for example, a political science professor who's a very big Second Amendment advocate and on the weekends creates YouTube videos at the firing range where he's shooting all sorts of different guns and reviewing them, or who weighs in on Second Amendment issues in the public sphere. You could have students say, I don't know, this guy is interested in guns. I don't want to be sitting in his classroom.
Sure. Yeah. And it's, I do think there is something about porn and sex that maybe just can be traced to sort of deep-rooted Puritan influence attitudes in this country about sex where it's just kind of sexual expression is seen as taboo outside of a few narrow contexts.
But it is protected by the First Amendment, right?
It is, yeah. I mean, the same way like other performances, right, that don't involve fucking would be protected by the First Amendment too. But in this case in particular, I think the way he was mixing it with promoting a vegan lifestyle and like
everyone
a
needs their
sex-positive lifestyle.
It's educational content.
There's like some commentary mixed in there on matters of public concern too, right? So, but attitudes. It's interesting to think about whether or not 20 years from now, because attitudes about sexuality have evolved in a more liberal direction in this country over time. And so, like, in the future, will we look back at this and kind of view it as moralistic and outdated, these sorts of punishments, the same way we now look back at, like, premarital sex or cohabitation? I don't know. But, but also, like, is there eccentric professors I don't think are a new thing, right? Like, I don't know. I feel like we all had one.
You kind of want them,
it didn't
right?
jeopardize your education. Yeah, sometimes it was like,
if you don't want to take the class, right? College students are adults for the most part.
Sure.
They don't take the class. And moreover, I think it was someone on the board who made the argument, is it going to harm our enrollment numbers? And then it's a small sample size, just one semester so far, but no harm whatsoever, right? So I have a tough time, and I've thought long and hard about this. Where would the harm come from?
So it was a University of Wisconsin lacrosse faculty committee in June that recommended the school take action against him. And then there was a hearing in front of the Board of Regents of the University of Wisconsin system on September 20th. And that's when they decided to fire him. And Connor, correct me if I'm wrong, we've been supplying him with an attorney?
Yeah, we hooked him up with an attorney, and they are pursuing this in district court, I believe.
Yeah, that would be the first place, right, if it's a First Amendment claim for it to go. All right, let's move now to the University of Pennsylvania, where we have had a years-long effort there to go after Amy Wax, who's a professor at the law school, for things she said in op-eds and interviews and allegations of things she said to individual students. She's very conservative. Many people say she's racist, and that's why she's been targeted at the school. Some things she stated. In a 2017 interview, for example, she said, "I don't think I've ever seen a black student graduate in the top quarter of the Penn Law School class, and rarely in the top half." Went on to say, "I can think of one or two students who've graduated in the top half of my required first-year course." She also stated that black students tend not to graduate at the top of the class, and added, "Anybody who teaches law school knows this to be true." Stated that no law professor can honestly say that blacks are evenly distributed through the class, top, middle, and bottom. So there she's talking about what she's seen in her experience as a University of Pennsylvania law school, presumably falsifiable, right? That's something you can look into, although I think they have blind grading at Penn. She also invited Jared Taylor, a noted white nationalist, white supremacist, for a mandatory lecture in her law school course. She stated, "Our country will be better off with more whites and fewer non-whites," stated that Asians have an indifference to liberty, lack thoughtful and audacious individualism, and that the United States is better off with fewer Asians and less Asian immigration. She's described some non-Western countries as shitholes and said that women on average are less knowledgeable than men. So that's a litany of commentary there that she's where she's commented on the performance in different contexts of minorities. So
when we do surveys to see if professors are okay with speaking their minds, I know which group she's in.
Yeah, right. But the initial response by the University of Pennsylvania Law School, I believe, in her comments surrounding black students and their performance in law school, was to remove her from teaching mandatory first-year courses.
Right. So she was already punished for that.
She was already punished for that. And then it was the Jared Taylor invitation and some of her other comments that were subsequent to that, where I don't believe she was necessarily talking about the performance of law students in her class, although I could be mistaken, talking about the performance of Asians in American society more broadly, where the university picked it back up again, issued this very long report that ultimately ended on the recommendation that the school take a major step. I think they described it as a major sanction against her, and she's a tenured professor. What are your guys' thoughts here?
It's kind of outlandish, right? You said unprofessionalism was the sanction, right? So for
sanction for unprofessionalism, and thanks, Connor. I should note what the actual sanction was. It was just announced after a 2-year investigation of Wax that she'll keep her tenured faculty role, she'll serve a 1-year suspension at half pay, and she'll keep her benefits, which is important because she's currently battling cancer.
So they've had a long time to investigate Wax, and zero discriminatory conduct in the classroom has popped up, right? So they use this unprofessionalism standard, and they hammer her for speech outside of the classroom. She wasn't giving these lectures to her first-year law students, right? She was writing about these, speaking about these on the circuit. To me, it seems like a weird justification. They were just looking for something to get her with.
If there was evidence, though, I think what you're getting at there, of her discriminating against actual students based on these beliefs, grading black students, for example, or Asian students harder than she's grading her white students, that would be something the university can and probably should take action against. No?
Mm-hmm. Yeah, absolutely. But this again, it kind of calls back to what we were discussing earlier about do you actually have evidence of the teacher failing to fulfill their professional responsibilities or violating the law by discriminating against students based on a protected characteristic like their race or gender? Or are you just projecting or predicting that's going to happen based on the views that they've expressed on sensitive issues like race and gender? And I think that's what's happening here. And again, the problem is that you can potentially apply that standard to a lot of other faculty members who have this. Amy Wax is not the only one who has said something inflammatory or controversial about sensitive political issues, right?
Penn has a long history of these kind of double standards, right? Wasn't it just past couple of months a professor posting on social media, Zionists drinking blood and all these things, right? You go back all the way to FIRE's founding with the water buffalo incident. So now they're establishing the precedent that, speech outside the classroom is grounds for sanction if students, parents, or donors complain. And I don't see how they can put that back in the bottle in today's environment on campus.
Well, let's steel man this, right? Like,
sure.
Why should faculty members to be able to speak freely on issues of public concern, even if it is caustic, even if it is a little bit racist, or a lot of bit racist, or even if it is offensive, right? Like, why should they have the freedom to do that?
Well, we want colleges to be the crucible of truth, right? And like any other crucible, it's going to get hot. We want people to have the widest range of free expression in this environment, which is sort of a microcosm of our country, a lab for the rest of our country to look at, because that's when we have that free, uninhibited expression on campus, we have the broadest possible range of ideas coming out through that process. And if someone says something that is really outlandish and provably outlandish, well, we prove them wrong. If someone says something that isn't provably true, and we don't, and we disagree, we express that too. But then having done that, we go out through the rest of the world with that knowledge and comport ourselves accordingly. If we start putting our thumb on the scale in the college context for speech, we're now saying we're not really looking for truth in these places anymore. We're looking for truth within the acceptable window of what we think should be true. And the problem is humans have a really long history of being wrong about things we thought should be true. My personal favorite is a monument outside Case Western Reserve. And it's a monument to a failed experiment. It was scientists who were going to prove the properties of voluminous ether, which is what we thought filled the universe, because we knew nature abhors a vacuum. So space couldn't be a vacuum. And they did their experiment, which was trying to measure the movement of light through the waves of the ether. And it turns out, no, actually, space is a void. And I appreciate the monument, like a monument to recognize our willingness to be wrong and how important that is sometimes.
And I think all the things we were saying earlier too about the problem of the government regulating hateful or offensive speech apply just as strongly.
Slippery slope,
in
right?
the context of higher education, right, and academia, where exactly, like applying a vague standard like unprofessionalism to expression of political viewpoints. I mean, it's very easy to see how that's going to go wrong on campus, particularly when you have a lot of campuses that lean very heavily in one direction politically or ideologically, right? Like that standard is very unlikely to be enforced in an even-handed, consistent manner against people across the political spectrum. It's going to be much more likely to be enforced against people, faculty and students who are in the minority and who have dissenting views from the campus consensus.
I mean, for example, let's say for the sake of argument, and I have no information at all about Penn's class rankings, what if there was some truth to the underlying accusation that some groups are underperforming at Penn? Well, wait a minute. If that's true, now we need to investigate why that is and try to figure out how do we assist these groups. If we instead make a rule that you can't say that groups are underperforming at Penn because that is biased, we are actually going to miss when that happens. And essentially, we're perpetuating a form of systemic racism because we can't actually say the system is failing people.
The concept of settled issues freak me out, right? Assuming we've pick your topic, everything we know, that's it. We're not going to push the boundaries any further. To me, that's what college is for. If you're saying, it's unprofessional to discuss certain things, you're accepting that advancement in that category is done.
Is it the same? Remember the same thing happened at Georgetown where the professor was caught on a hot mic, I think, saying that something about like the minorities in her class, like she weren't performing as well. She was like expressing her honest opinion to someone. She didn't think she was being recorded, and Georgetown fired her.
Yeah.
Instead of like you're saying like, oh, maybe this is a problem if they look into and see what we can do to ensure that our like students, regardless of their demographic category, are performing, have an opportunity to perform well in our school. They just said, no, let's just fire this professor and prevent this issue from being examined.
Yeah, that was ridiculous. I'm looking at some of the letters that we've sent to the University of Pennsylvania Law School around Amy Wax, and it wasn't just free speech issues. I'm looking at a letter from June 1st, 2021, where we talk about due process concerns with the investigation of Professor Wax. We write, despite being notified of the investigation on May 18th and making repeated requests to your office for copies of the relevant complaints, Wax has yet to receive written notice of the charges against her. Penn Law's faculty handbook clearly provides that should a question arise regarding the possible infraction of university behavioral standards, the dean or provost shall provide a written description of the charges to the respondent if requested by the respondent in writings. This is something we often see, and it's one of the reasons FIRE got involved in due process work from our founding, which is free speech violations, academic freedom violations are often paired with due process violations. It's hard to defend yourself when you don't have the complaint and the evidence in front of you, but too often that is the case on college campuses. I want to turn now to the third professor, Moral Finkelstein, at Muhlenberg College, which is a private Lutheran school in Allentown, Pennsylvania, who was fired for her pro-Palestinian advocacy. This past January, Moral Finkelstein reposted an Instagram story from a Palestinian-American poet that stated, "Do not cower to Zionists, shame them, do not welcome them in your spaces, do not make them feel comfortable. Why should those genocide-loving fascists be treated any different than any other flat-out racist? Don't normalize Zionism. Don't normalize Zionists taking up space. She was fired this past May, and there might have been, their suggestion, added pressure from the Department of Education for the university to fire Professor Finkelstein. Department documents released last week state that Muhlenberg received 8 shared ancestry complaints about her speech online and in the classroom. And then once this news that she was being fired came out, Muhlenberg resolved a federal investigation with the Department of Education surrounding its investigation into violations of Title VI of the Civil Rights Act of 1964. So what you have, because that might have gotten a little confused, is a Department of Education investigation, some complaints about this professor. After this professor learned about the investigation, I believe, the next day she tweeted out that Instagram repost that or tweeted out, I'm mixing platforms here, that "Do Not Cower to Zionists" post. Then she gets investigated. She gets fired in May, and we first learn about it. And I believe this is the first time since the October 7th terrorist attacks that a tenured faculty member in the United States has been fired for pro-Palestinian advocacy. So you have a conservative law professor fired at Penn, a liberal professor at Muhlenberg fired as well. Both of them are tenured. What does the state say about the state of academic freedom, Connor?
It sucks, right? Everyone points to the McCarthy era. It's at least the darkest days for tenure and academic freedom in my lifetime. I point back to the Amy Wax professionalism conversation, right? If we're going to start using these, justifications to kick faculty off of campus, where does it end? Amy Wax on race one day, a liberal professor on pro-Palestinian advocacy the next. That can be weaponized too easily for my liking.
But if she reposts something that says "Do not cower to Zionists, shame them, do not welcome them into your space," isn't there a reasonable suspicion or idea that she maybe won't welcome Zionist students in her spaces?
There could be, and that there were complaints suggests maybe there were students who felt that way. What the federal obligation here is, it's very technical. The school has to do something. It has to take some ameliorative step to ensure that students feel welcome. It does not have to censor anything. It does not have to fire anyone. So that's what the legal obligation is. The school must take some step, and that step could have been reaching out to those students and saying, "Hey, we talked with her. She understands her obligations. Let us know if things continue." It could be, get everybody therapy. It could be helping people switch classes if they want to switch classes. Like, there's a great deal of the only thing bounding what schools can do here is their creativity and the First Amendment and I guess really civil rights law in general. So there's nothing about the situation that compels them to take disciplinary action or to censor speech or to fire anyone.
Kind of make the point again that we can't, if we want to have academic freedom, you can't automatically assume that every opinion that a professor expresses on social media automatically translates into unprofessional conduct in the classroom. I think especially when you consider that social media kind of rewards sensationalism and overheated rhetoric, and so I think you if you have actual evidence of unfair treatment in the classroom, that's certainly something a professor can be disciplined for, or if they're pervasively using class time to just as the soapbox for their political opinions that don't have to do with the subject of the class. The university doesn't have to tolerate that either. But otherwise, you just want to be careful not to set a precedent where no matter where any strong opinion a faculty member expresses on social media or outside the classroom can be used against them.
Yeah, and we've been talking about Title VI here, which governs race, color, and national origin. Colleges and universities can't discriminate on that basis, but it's been interpreted since 2004 to expand beyond that toward shared ancestry, national origin that has a kind of religious characteristic to it, as well as ethnicity. And so that's how you get Jewish students covered there. Query whether it would protect Zionism, which is a political movement, but has deep connections to the state of Israel, for example. All right, our last topic for the day. Nassau County's mask ban. New York, Nassau County banned wearing masks in public except for health or religious reasons. Nassau County Executive Bruce Blakeman signed the legislation named the Mask Transparency Act on Wednesday, August 14th. Blakeman said this is a broad public safety measure. What we've seen is people using masks to shoplift, to carjack, to rob banks, and this is activity we want to stop. The law in Nassau County considers it a misdemeanor, punishable by up to 1 year in jail and a $1,000 fine for individuals to wear face coverings that conceal their identity in public. As I noted, there are exceptions for those wearing masks for health, safety, religious, or cultural reasons, as well as for the peaceful celebration of holidays or events where masks are traditionally used. Plug for Halloween, which is coming up, one of those holidays where masks are traditionally used. A lawsuit was filed by the Disability Rights of New York that sought a temporary restraining order and a preliminary injunction to stop the enforcement of this Nassau County mask law. The lawsuit involved two plaintiffs with different health conditions who wear medical-grade masks for protections. They expressed concern about being harassed or potentially arrested due to the newly implemented mandate, and a judge dismissed the lawsuit last week, stating wearing masks for medical reasons is expressly excluded from the Mask Transparency Act reach by its health and safety exception. But this question of masks more broadly, right? COVID came about. Everyone, under pain of punishment in some cases, had to wear a mask. And now we're saying, no, can't wear masks because they're being used in the commission of crimes, or at least that's the justification.
Well, the part that I love is the masks are being used to rob banks. Oh, somebody noticed that finally. Well, where's my rope transparency act? It's being used to tie damsels to train tracks. It's like the old-timeyest justification you could find for a mask ban.
Also, they've arrested, I think, one person under this law so far. And was he robbing a bank or carjacking? No, he was wearing a keffiyeh over his face at a pro-Palestinian protest. And by the way, I guess with these exemptions for health and religious reasons.
And also for holidays.
So I guess all Bonnie and Clyde had to do was she puts on a burqa.
That's what it was.
And then he puts an N95 mask over his face, and then they never got caught.
But these laws, some of which had to be suspended during COVID, are sort of ancient, right? You had states pass these laws to go after the Klan, for example.
In New York, the law was from 1845. When tenant farmers were uprising against their landowners and would dress up as women and natives to obscure their identities. And then that law was on the books until the repeal was signed by Governor Cuomo. Mm-hmm. So we lived through a long period of this. Now, there was one big incident in the 90s about the Klan wanting to rally in New York and Giuliani, as mayor, refusing to give them a permit, and then they sued, and eventually the court said, you got to give them the permit, but they can't wear the masks. And it ended up being, 18 people standing for 90 minutes silently while a very angry crowd, some of them wearing masks of Mayor Giuliani, assaulted cops. So it was a very strange energy. But yeah, this has been New York for a long time.
Well, are there problems with mask bans from a First Amendment perspective?
Yeah.
Yeah. Oh, yeah, I think so.
From two angles. So one is that masks themselves can be expressive. So that's one way in which I think the bans implicate the First Amendment. The other way is that they implicate the right to speak anonymously. Mm. So you might want to wear a mask, like, for instance, if you're a member of the Ku Klux Klan. But not only that, I think people really focus on that, and that's where a lot of the case law and the plaintiffs or the defendants in criminal prosecutions are Klan members. And I actually think that's unfortunate, and in that I think it influenced some of the bad decisions, kind of the bad facts make bad law, old expression. But yeah, so the idea is that you may want to disguise your identity if you're expressing a particularly unpopular viewpoint that can result in you facing harassment or retaliation from the government, from your employer, or just for people, putting a video up of you on social media. And I think that threat is even more acute today, where you have government using facial recognition technology because we have social media. Everyone's walking around with a phone in their pocket. So it's and a lot of these decisions, including the ones that upheld mask bans, they were from like the early 2000s, from the 90s. And I do wonder if maybe some of those courts will come out differently today, given the kind of changing landscape and the greater threat of retaliation and harassment for speech in public.
Could you have a mask law that makes wearing a mask in the commission of crime an aggravating factor? for example? Like, let's say you have a law against robbing a bank, right? Theft, I guess.
We should do that if we haven't, by the way.
Yeah, we should.
We
right?
should definitely make that not legal.
But if you do it wearing a mask, like the punishment is greater, right? Because
There's no reason we
I think
can't do
that's
that.
perfectly constitutional.
okay,
And that might actually be a deterrent for the crimes in particular that they're concerned about, where if it's 30 days to smash a window and 90 days if you do it wearing a mask, I might just prefer to, throw the brick and see if I can't run faster than the cop.
Yeah.
Well, not me, but the hypothetical person.
In that situation that you're describing, you're not doing collateral damage to protected speech. And the problem with a lot of the existing mask bans is that they'll just more broadly just say you can't wear a mask to conceal your identity for any purpose. Gotcha. All right. So, and then that's how you get. I'll give you another example of like an older case that struck down mask bans under the First Amendment from the late 70s. Iranian American students who were protesting the Iranian government, and then one of the cases they like put pamphlets in between their glasses and their face to conceal their identities because they were, I would say, reasonably afraid of retaliation from the Shah of Iran or against their relatives who were still living there. And the court took that into account and said, yeah, this is a burden on your right to anonymous speech. And that grows out of earlier Supreme Court decisions like NAACP v. Alabama that said that the state of Alabama couldn't force the NAACP to disclose its membership list to the state, and they provided evidence that they would likely face harassment retaliation. I think this was like back in the 1950s, where that was a very unpopular view. So again, don't get fixated on the fact that this is often enforced against the Klan because it's just as easily enforced against other views that people won't find as abhorrent. And it's even more recently also been enforced against people protesting racism and police brutality.
yeah, political speech has a deep connection with anonymous speech here in the United States. Obviously, the Federalist, the Anti-Federalist papers, Common Sense. People didn't know that it was Thomas Paine who wrote that initially. I think the byline was just an Englishman.
Precisely because the fear of seditious libel. Like these were things people could be executed for. So fear of retaliation from the government for their speech was what the founding fathers were trying to avoid in part when they crafted the First Amendment. So it's just an inseparable thing, anonymous speech and freedom of speech, and to see how anonymity has been treated poorly, both in the case of people think you can regulate online speech and require people to identify people who want to wear masks as part of their protests. It's kind of depressing because it's a piece of First Amendment doctrine that needs to be understood better by the public. It's up there with fire in a crowded theater.
Yeah, it'll be interesting to see if the Supreme Court will ever take up this issue. It hasn't spoken on this issue of whether or not mask bans are constitutional. There's just various conflicting lower court rulings, some of which extend NAACP v. Alabama and other cases where the government's forcing people to disclose their names or addresses or identities to masks, to requiring people to unmask themselves. Some courts have said that's also implicates the right to anonymous speech just as much. Some have said, no, it's different when you say you have to disclose your name or address versus just saying you have to appear in public with your face exposed. So we'll see if the Supreme Court ever settles that.
We'll see. Fingers crossed, right? We need to get some clarity on that. But I think if you extrapolate, as you know, existing First Amendment principles, you arrive at the conclusion that you can speak anonymously. We've seen this being used in other countries. For example, during the Hong Kong protests, you had the protesters carrying yellow umbrellas to help prevent the facial recognition technologies that are prevalent there, because the Chinese government very much wanted to target political dissidents in Hong Kong.
Occupy Wall Street protesters wearing those Guy Fawkes masks, V for Vendetta, which again you could argue is both expressive and a way to remain anonymous.
Can I call out my T-shirt before we wrap up here? Fire just relaunched our store on our website. You can find it at the top of the website, thefire.org, or go directly to it at shop.thefire.org. This is our Free Speech Makes Free People T-shirt that is incredibly popular. We've got this and much else in that store. So if you're interested in getting some Fire swag and signaling your support for free expression and supporting the organization by shopping at our online store, please do go to shop.thefire.org or just go to our website, thefire.org, and go there to the shop button at the top of the webpage. I want to thank you guys for joining us. Every couple of weeks, if not months, it feels like lately, we do this news roundup. So we'll try and get another one in before the end of the year. Thanks again for joining us.
Thanks,
Thank
Nico.
you for having me.
All right, that was Fire's News Roundup with Fire employees Aaron Terr, Connor Murnane, and Adam Goldstein. I am Nico Perino, and this podcast is recorded and edited by a rotating roster of my Fire colleagues, including Aaron Reese and Chris Maltby, and co-produced by my colleague Sam Lee. To learn more about So to Speak, you can subscribe to our YouTube channel or our Substack page, both of which feature video versions of this conversation. We also put the full video up on X, and you can find our handle there by searching for Free Speech Talk. You can also find us at Facebook, and you can send us feedback at sotospeak@thefire.org. Again, sotospeak@thefire.org. And please, I ask you every episode, if you enjoyed this episode, please consider leaving us a review on Apple Podcasts or Spotify. Those reviews are the single best thing you can do to help us attract new listeners to the show. And until next time, I thank you all again for listening.